Yes, this is the point, because it's destination for touristic purposes. So the point about the use of the international waters as a non-European place can trigger these comments that you raised. And don't you think that concerns about abusive practices might be grounded if it were sufficient always, with no limits, simply to enter international waters to interrupt the clearance period?
Sorry. Well, actually, no, and not only because we argued in that way, but also for several other reasons. On the one hand, I mean, one may disagree with the regime, but the possibility to combine several periods of temporary admission is clearly provided by the EU rules that we have discussed. And also, there are the well-known guidelines published by the European Commission, according to which, and I quote, "You are not limited to a single period of temporary import. You can sail the yacht out of the EU, and when you return, a new period of temporary admission can begin." Sailing the yacht out of the EU, I mean, there is no reference to entrance into the port of a third country.
Yes.
Clearly, they need, I mean, these guidelines, they are probably not binding for the EU Commission, but I mean, they need to be complied with in order to protect the legitimate expectation of operators. They are not binding for the Commission, but they are, let's say, binding when they are when you want to use them in order to protect the interest of individuals, let's say so. And also, there is another point which was, which I believe played a role in the final outcome so far of this dispute, because we need, we need to take into account that we are discussing EU rules, which need to be applied, let's say, uniformly in a uniform way across all member states. So if we think about the anti-elusive viewpoint, this may be probably true, or I don't know, I can understand this argument is raised, let's say so, from an Italian perspective, because essentially entering into international water from the Italian perspective may seem easier than reaching the port of a third country. But this is not the case in several other member states. Just, let's say, take into account, just consider all the coastal member states that border or are in any case located close to a third country: Croatia, Greece, Spain, Sweden, and probably, let's say, in other period also Estonia and Finland, for example. In all these cases, I mean, the port of a third country can be some, let's say, few hundred meters away, and on the other hand, international water are a uniform, let's say, parameter. They are always 12 miles of the coast. So in my opinion, actually, using this parameter is, let's say, more in line with the need to protect the equal treatment, which is a general principle of EU law, of economic operator, and in particular owners in the economic sector that we are discussing today, regardless of whether they are established.
Okay, understood. A very critical trade-off. And what was the outcome of the appeal brought before the Tax Court of Appeal of Genoa then?
Totally different, and maybe also because we pointed out the principle just summarized by Luca. The Court of Appeal paid closer attention to the content of the rules, the lettera of the rule, as we say in Italian. On the basis of the articles mentioned by Luca, 215 of the UCC and 139 and 141 of the EU regulation, and also referring to the Commission guidelines mentioned by Luca, the Court of Appeal recognized that for the purpose of interrupting the discharge period, no EU or national provision imposes any further requirement beyond the mere exit from the territory of the Union, I mean the water of the Union. According to the Court of Liguria, therefore, the fact that the European Union and national legal framework does not require reaching territorial waters and or docking in the port of the third country allows the court to conclude, and quoting the decision, that contrary to the findings of the first instance court, exit from the custom territory of the Union is per se enough to complete the export formalities for a yacht and consequently to interrupt the period of temporary admission. So a very clear and logical application of the rules. And as a consequence, the court upheld the appeal and annulled the Imposition Act, stating that the yacht was never imported and therefore no VAT on import was due.
And this is our gem in the case law scenario for temporary admission. But let's go to the also relevant, highly relevant criminal law aspects, and specifically inconsistency between the second degree ruling that VAT is not owed and the seizure was pursued according to the tax assessment and to the first degree of the Court of Imperia. At the beginning of the discussion, you mentioned that the owners were also involved in a criminal proceeding stemming from the same conduct. Had the criminal proceeding been closed following the ruling of the Tax Court of Genoa, or was it pending? Is it something you are still fighting against?
Okay, well, let me start by saying that actually we do not handle directly the criminal side of this case. We are only supporting the, let's say, the other professional, the other lawyers which are specialized in this field and are assisting the owners. However, let's say even it may seem not so logical, the criminal proceeding is still ongoing. This is essentially a consequence of what I mentioned earlier. I mean, the dual track approach to tax and criminal justice that characterize the Italian legal order. This is mainly due to the fact that from, let's say, a strictly legal viewpoint, tax court rulings are not binding on the criminal courts. Which may, in theory, therefore reach a different conclusion. And actually, even the opposite scenario is true. I mean, criminal rulings are not binding for tax courts, with only, let's say, an exception which have been codified by Article 21 bis of Legislative Decree 74 of 2000. Let's say, if we think about, in my opinion, the full autonomy of the two jurisdictions makes sense mainly in the opposite scenario compared to the one that we are discussing now. I mean, it's a matter mainly of related to the standard of proof. In a criminal proceeding, the standard of proof is higher, not beyond any reasonable doubt. So it makes sense that if a criminal ruling does not find that a given taxpayer was guilty of a criminal offense related to that tax, this ruling cannot always prevent a tax authority from concluding that in any case, let's say even if there was no criminal offense, the tax was nevertheless due. But I mean, if you think about the opposite scenarios, the one that we are discussing today, the full autonomy of the two jurisdictions seems more difficult to apply in practice. Essentially because, I mean, even if, and despite the lower standard of proof, a tax court finds that the tax was not due, it's quite, let's say, hard to imagine how a criminal court can conclude beyond any reasonable doubt that such tax was evaded, so there was a criminal offense related to the evasion of that tax. It's very, very, let's say, unusual, I would say.